Please turn on your camera and introduce yourself to the class.
Okay, sorry about that. Hi, good afternoon, everyone on the call. My name is Osayame Mokogu. It will be Yame for short. I'm an Assistant Chief State Counsel at the Ministry of Justice, Edo State, Nigeria.
Awesome. Welcome.
Pleasure to meet you all.
Yes.
Thank you, sir.
Okay, good afternoon once again. Caroline, welcome. If you look at the chat box, Prof has stated or posted the revision we're having today. Says greetings and welcome to the 14th day of the 12-week lectures. Today is a revision of the following topics that we have considered under week 3 as follows. 1. Interpretation of legislation, statutory interpretation. 2. Literal rule of interpretation. 3. Golden rule of interpretation. 4. Mischief rule of interpretation. 5. Mongo's principles in legislative drafting. 6. Purposive approach to interpretation of legislation in civil law jurisdiction. 7. Interpretation Act and other aids to statutory interpretation. So we look forward to our usual interactive session. This is coming from our coordinator, Professor Tonye Jaja. Thank you, Prof. Welcome, ladies and gentlemen. We'll go straight into our lecture for the day, and those who will be able to join the class will join in due course. Thank you very much.
Okay, so today's class will be interactive. We want questions to be asked. I'm not going to do the talking today. We want you to ask questions so that we can have a discussion class. Beginning from each of the topics, what you understood from any of those topics, then we'll have a discussion. All right, so let's have your questions. From topic number 1, what did we say about interpretation of legislation? How is it related to legislative drafting? If you do not answer, I will start calling one by one. We began with interpretation of legislation. We said there's a relationship between interpretation of legislation and legislative drafting. What is the relationship? The rules that govern interpretation and the rules that govern drafting. How are they related?
I am here, sir. There's a hand up.
You can start calling the people. Okay?
Mr. Oscar's hand is up.
Okay. Thank you, Mr. Oscar. That's right. So how are the rules of drafting related to the rules of interpretation? Those of you from Lesotho, you remember we said every language has its rules. So how do you relate the rules of interpretation and the rules of drafting?
He said that in drafting, you must make sure that whatever you're drafting is not in conflict with the constitution of the. Okay.
Yes.
I said in drafting, you must make sure the land or with any existing law of the land.
Okay, great. So can you tie what you just said now to any of the rules of statutory interpretation? What you said is correct, but can you tie it to any of the rules? Can you relate it to any of the rules?
Let me try. one of the rules of interpretation is literal rule.
Yes.
If the courts want to interpret, they would interpret whatever they see whatever they see in the law is what they will interpret.
Okay.
That is why the Mongo's principle is. That is why it is advisable to apply the Mongo's principle when you are not in doubt. It is better to be on the surplusage.
Yes, but I don't want you to drift out of the question and the answer. You're bringing in Mongo's principle. It's not totally out of place, but do you understand what Mongo's principle is? One, what you said is,
Yes, sir.
drafting, you should ensure your draft does not conflict with the provisions of the Constitution. That is correct.
Which is good. And look at the chat box. I didn't write it. One of the things we learned is that there are 12 Scalia canons of legislative interpretation of the Constitution. Then we have the blue pencil rule, we have the red pencil rule. The interpretation of the Constitution is different. The rules that apply is not these three rules: golden rule, literal rule, and mischief. So who can tell us? You started well with.
Okay. Let me say so. Let me add something, sir.
Mm-hmm.
If the law that they are about to interpret is in conflict with any of the provisions of the Constitution or existing law, they will apply the red pencil rule.
Are you sure? Madam, just follow it gently. You are bringing in a lot of things. The question is, what is the relationship between the rules of drafting, legislative drafting, and principles of interpretation, legislative interpretation? Restrict yourself to that question. You are saying a lot of things that are correct, but are being misapplied. Do you get it?
Okay.
There's a hand up. Teboho, you raise your hand first. Yamen, we will come to you after Teboho. Go ahead, Teboho.
Okay, Beneza, I wanted to try here. We have the mischief rule as one of the rules we use to interpret statutes. So, in line with the mischief rule, in interpreting the statute, we try to understand what was the problem that the legislature was trying to solve.
Okay.
Now, as a drafter, you need to know exactly what the legislature intend to solve when you get instructions to draft. So that is how they are related. Once you understand the mischief rule, then you will be able to draft in line with whatever problem is being solved.
Beautiful. Thank you very much. Okay. Yamen, you have the floor now. You may attempt your answer.
Okay, so yeah, hi. I hope you can hear me. So I will also follow Teboho's reason. That was what I was going to say. That language of drafting and interpretation, it's the language that leads to the interpretation. So that a draftman must always know that there are three basic things that the courts will look at when interpreting a law that has been drafted: the purpose, the literal meaning, or the consequence. So for any of the three, it will either be mischief, literal, or golden. So when drafting, we must make the legislation clear enough to show that as this is the literal purpose, this is the literal meaning, this is the purpose, and these are the possible consequences. So that way, the court can easily interpret the legislation.
Excellent answer. However, I would want to caution on your choice of words. Instead of using purpose, use intention of the legislature, so that you do not drift into purposive rule of interpretation or purpose clause in the bill.
Noted, sir.
Thank you very much.
She didn't attend the class on purposive, so.
Okay, so let's make progress. We would want to have Honorable Kolade give us an answer to this question. Honorable sir. Madam Joyce, you are next.
Thank you, Prof. and our Barrister Ebenezer. My own thinking is that for every law or for every bill that is or law that is drafted by the National Assembly or by the legislature, the judiciary will be the one to interpret it. So for the interpretation to find a platform, it must come from the legislature. So there's a link between the legislature and, of course, the executive. In trying to draft the bill, the content of the bill it can be interpreted by the executive from the literary point of view, and of course from the golden interpretation rule, or from the mischief. So there's a nexus really between a very good draft and, of course, a very good interpretation.
Yes, sir. We have established there is a nexus, but we are looking for what that nexus is. That's the context of our question. No doubt there is a relationship between the two, but they are parallel lines. They can stand independently. However, we want to merge them, which is actually what happens as a draft person. When you are drafting, you have to merge these two in your mind to bring out quality bill that when it becomes law, it will not bring an issue. In fact, not just one of the major litmus tests of a quality bill or a well-drafted law is that it rarely goes to court for interpretation, because there is no ambiguity. Everything is clear. It is when there are ambiguities, it is when there are deficiencies in the bill that eventually becomes law that it becomes difficult to implement.
Yes.
And we will now be looking for the court to interpret and show us the right way to follow.
Yes.
What line of action?
That woman. Finance.
They didn't call me today.
So, I don't know if you understand my explanation, sir.
Yeah, I do.
Is it
Yes.
the
So,
woman?
we want to establish that relationship.
No.
They said law.
For example,
It's the finance
what
person.
Teboho said earlier,
What's going on?
and I can't mute you from here. I can only remove. Okay. So, Honorable, let's get, yes. The question is, what is the relationship between the rules of interpretation and rules of legislative drafting? We have established the three cardinal rules: literal, golden, and mischief. How do you, as a drafter, where do these meet? So, Teboho mentioned that if you are drafting, you have to draft in such a way that the court can easily interpret literal rule. Madam Uju mentioned that the court will only interpret what is given to it. So that means you must bear in mind that as a drafter, look out for the mischief that the law intends to solve, and that is also the point Yamen mentioned. That is just one. What other, where else do the two meet? Honorable, you have tried. Teboho, you raised your hand again, so can you give us another 1 point?
Yes, I may not be sure about this one. My colleagues will assist. I think the relationship with regard to literal rule is brought about by the mongoose principle. In terms of the literal rule, the judges are confined to the text of the statute when they interpret the statute. That means whatever is not in the statute, they cannot interpret beyond what is not in the statute. This is under our common law jurisdiction, as opposed to what they have in civil law jurisdiction.
Excellent.
Like in the case of that cyber stalking case, since the cyber stalking was not described in the act, the judge could not do anything. So to avoid those situations where we find that the law is lacking, the mongoose principle allows drafters to write more. Perhaps that is why we have bulky acts in our common law jurisdiction as opposed to what they have in civil law jurisdiction, since the judge can go beyond what is written as long as he confines himself within the purpose of the statute. So the mongoose principle connects the interpretation and the drafting in that way, as I said.
Thank you. Madam Muju, you see how he connected it. You got it right by mentioning, but linking it to application was where you didn't quite get it well. Okay, thank you. I said that Joyce is next. Joyce, are you still on the call? Madam Joyce? Okay, I think network took her out. Lekaka, you have been part of the class. Liteboho, you have been in class, so let us hear from you. Tumelo, welcome. Good afternoon.
Thank you, leader.
We are having a question, we are having a revision session, and the question is, what is the relationship between the principles of drafting and the rules of statutory interpretation or rules of interpretation of legislation?
Oh, thank you very much, leader. I believe the meeting point of the two rules is the fact that both are used to guide the legislative drafter as far as to what kind of product should be delivered, to the extent that when the legal drafter understands the rules of interpretation, he is able to avoid the pitfalls that can be caused by relaying a message through drafting that will not necessarily be expressed by the rule of interpretation that the drafter would want to comply with. However, when we look at the rules of legislative drafting, they also guide in order to build conformity of the practice, to say that a legislative drafter who has given his services in another country, which is of a common law jurisdiction, could still come up with the basic structure of a draft that conforms to a common law jurisdiction country, because they have subscribed to the rules of legislative drafting that allows for the work to come out in a certain standard. Thank you very much.
Thank you very much. Everything you said summarized in one word: standardization of drafting. Once it is within the common law jurisdiction, basically the structure, the content, the inner details, particularly the principal provision, there might be little differences because of what the law intends to achieve, might be different. But If you look at it, the structure, the format are basically the same because both rules were well applied. Thank you very much. Who just joined?
Let's ask the question. The rules of interpretation of the Constitution, how does it apply to drafting the Constitution or amendments?
Did we get the question? That's the second question. The rules of interpretation of the Constitution, how does it apply to drafting or amendments? Did we understand the question?
What are the rules of interpretation of the Constitution?
I think we said we have 12 rules of interpretation of the Constitution. And I remember the blue pencil rule and the red pencil rule.
What are the difference between the two rules? Because Madam Uju also mentioned it. What are the difference between the blue pencil rule and the red pencil rule?
In line with the blue pencil, we cancel clauses that are in contradiction with the Constitution. While in line with the red rule, pencil rule, I think we cancel the entire statute if it conflicts with the Constitution.
Beautiful. That is it. So when you are drafting, you must understand firstly that the Constitution is the ground norm and that there is nothing you draft in conflict that conflicts with the Constitution that will stand. So what it means is, as you are drafting, firstly you have to acquaint yourself with the provisions of the Constitution, one, and the rules of interpretation of the Constitution, so that when you draft, you ensure that you do not draft what will either be jettisoned using the blue pencil rule or what will be entirely thrown away using the red pencil rule while interpreting, because they conflict the provisions of the Constitution. Any other attempt, please? Uren, welcome to the class.
Thank you, sir. Good afternoon.
Welcome to the class.
Thank you so much, sir. Sorry for joining late.
No challenge. Okay, so we are having a revision revision session to see to what extent we understand and can practice what we are being taught. So the question is, what if we have dealt with question 1, 2 now is, what is, let me even rephrase the question. What is the relationship between legislative drafting and the rules of interpretation of the Constitution? The principles of legislative drafting and the rules of of interpretation of the Constitution, not generally statutory interpretation. The canon rules of interpreting the Constitution.
Hello, sir.
Yes, sir.
Please, sir, help me rephrase the question again.
Awesome. I said, what is the relationship, or how do you apply the rules of interpreting the Constitution to legislative drafting?
Okay, sir. The rules of interpretation of the Constitution, as we were taught by our amigo professor, they are number one, the neutral rule, the mischief rule, and the golden rule. And
let us correct that. It's good. That's the essence of what we are doing. There are 12 rules of interpreting the Constitution. 12. Then the 3 you mentioned are the rules of general interpretation of statutes, legislation. But when you come to interpreting the Constitution, there are 12, which includes these 3 and 9 others. 2 of which are the blue pencil rule, the red pencil rule.
Okay, thank you.
Let us differentiate it.
Okay.
The 3 you mentioned are 3 rules of statutory interpretation, but when it comes to Constitution, there are 12 rules of interpreting the Constitution.
All right, sir. Thanks for the correction, sir. So the rules of interpreting the Constitution allows a drafter to be conscious of possible contradiction, maybe in an attempt to draft a legislation, so that in the course of drafting, he or she would not contradict the provision of the Constitution. And in the case where it contradicts, it will amount to inconsistency, and such legislation, possibly, or the portion or the provision, could be declared null and void. So the relationship is that it makes one to have to be conscious of not flouting the provision of the Constitution in the course of drafting legislations. Thank you, sir.
Awesome. You know why I will take your answer? You were not here when this answer was given by someone else. So thank you very much. Prof, next question, sir.
Oscar, please, can you post the 12 rules of the canons? We don't say rules, canon. Those of you that are Catholics, if you know what a canon is, how is a canon different from a rule? Those of you who are Catholics. What is the difference between a rule and a canon? What is the difference between when we say the canons of statutory interpretation? Canada held that the Constitution is a living tree. So even if women were not allowed to vote, now, because the Constitution is a living organism, it has grown to the point where women should be allowed to vote. So it's a canon of interpretation of the Constitution. Doctrine is also a stronger law. Those of you that are Catholics, the doctrine is only propounded by the Pope, whereas other rules, other dioceses can do rules. So these are things, Oscar, so look at the 12 canons of interpretation of the Constitution. I'm going to add the Living Tree Doctrine, 1932. So who can take the first canon of constitutional interpretation? Yes? What's the first one? Who can take it? Ebenezer, please go and call them. Call each person.
Noted, sir. The canons are posted on the platform.
Yes, I would like
just
to
look up the in-call messages. You will see the canons there. So we want you to take them one by one. So I'm going to call your names. Before. Let me start there. Liteboho, tell us about 1. Canon number 1. Effect should be given to every word. Canon number 1. Can you help us with that? Hello, Liteboho. Can you hear me? Malefesani.
Hello, good day, Ebenezer.
Okay, look at the in-call messages. It's posted on the platform there. The 12 canons of statutory interpretation of interpreting the Constitution, as stipulated in the case of AG Federation, AG Bendel State against AG Federation 1981. I have posted the case there. So, can you give us your understanding of rule number 1, canon number 1? It says effect must be given to every word. What do you understand by that?
Okay, can I try maybe the next one?
Awesome. Anyone you can.
Then my colleague maybe should take the first one, then I will follow.
No, start with your own. Anyone there you can give us interpretation on. Just go ahead.
Let me take the Living Tree Doctrine.
Great. Go ahead.
You will correct me if I'm not correct. But I believe it means that as one of the 12 canons of the interpretation of the Constitution, it means that the Constitution should be taken as an evolving tool, meaning it is open to having amendments. So we have to adapt to societal changes and changes in legislations.
Great. You have to adapt the legislation to suit the present growth level or the present stage the society has evolved into. Do you get? You adapt the Constitution to meet and solve an existing societal challenge per time.
Yes.
You do not say, as it was in the beginning, is now, ever shall be, world without end. The Constitution is not cast in stone. So that's the reason we have periodic amendments. And when we amend, the amendment should not just be to fulfill all righteousness or for formality purpose because there is need to amend. The amended version of the Constitution should reflect the present civilization of the society and solve existing challenges of that time. Next person, please. Okay. Let me call on Uren. Okay. Teboho, your hand is up. Go on, please.
Okay, I will try, even though I'm not certain I got the question clearly. I will try with the first one. Effect should be given to every word.
Yes.
For me, it goes back to the literal rule. Should be given an effect because it confers rights and privileges which are enforceable. I think in line with this rule, which that are not enforceable.
Not just that. In addition to that, you do not just put idle words in the Constitution. Every word you are putting in there must be relevant and has a role to play, such that if you remove the word, that particular section will no longer make sense or will no longer have the force of law. So you do not just put that. So this brings us back to the principle of economy of words, except where there is need for explanation. Every word you are using should be effective.
Ebenezer, have you been thrown out?
Sorry, my network was misbehaving. So, Uren, I said, look at the in-call messages. We have posted the 12 canons of statutory interpretation. So, look up any one out of the 12. We have taken number 2. We have taken the Living Tree Doctrine, and we have taken number 1. So, which other one can you attempt? While we wait for her, any other person can volunteer before I call your name, because I will call your name. Selbol, welcome. Good afternoon. You joined late. Okay. Tumelo, go ahead, please.
Thank you very much, Ebenezer. I wanted to address the 12th canon that speaks to the issue that words of the Constitution are therefore not to be read with narrowness. My understanding is that because the Constitution is the foundation of a society, when we interpret or look at the specific words, we are supposed to also bring into context what it's trying to achieve holistically. That is, when it, for example, if I say one is granted the right to life, the right to life should not just include whether I am breathing, but should also include aspects such as my physiological and psychological well-being, so that the Constitution is able to afford that general foundation of life. I think it is a principle that just simply says, as drafters, we should be cautious that we are writing a document that has many implications to itself, and we should always be conscious of the scope that it should carry with it as a ground or founding document. Thank you.
Thank you very much. Excellent contribution there. Thank you. Words of the Constitution are therefore not to be words of the Constitution are therefore not to be read with narrowness, meaning that you cannot say it must be literal rule. This is what it is, and that is what it must be. We had the recent election we had in Nigeria. A section of the Constitution came up because it provides that for anybody to be the president of Nigeria, the person must have won 25% of the states and the Federal Capital Territory. The sitting president won at the states but didn't win the Federal Capital Territory. It became a constitutional issue. And this section 12 came, canon number 12 came to play. do we interpret and as conjunctive and remain narrow-minded that it says and it means FCT? Or did the intention of the drafter, did they mean that FCT is superior to other states and that you must win FCT before you become the president, even when you have won like even 30% outside? And they gave judgment in favor of the sitting president. However, the constitution is undergoing amendment now, and I had the privilege of being close to one of the participants. Minded him. I say, sir, this particular session that had issue during the last election, please, you people should look into it. In my presence, he made a phone call. So they are working on it. By the time the amended constitution is out, I believe that session would have been worked on. Okay, let's make progress. We have limited time. Somebody's hand is up. Yes. Mufasa, Masufa, go ahead, please.
Yes, Nade Ebenezer, it's Masufa.
Okay, the H is silent. Thank you.
Yes. I was going to say we have seen a situation in Lesotho whereby I think it's supposed to be Canon 2 that a construction nullifying a specific clause will not be given to the Constitution unless absolutely required by the context. We have seen it in a recent case before the Court of Appeal and the High Court of Lesotho, whereby the initial constitution said if there is a vote of no confidence against the Prime Minister can decide to dissolve, call for elections, or can step down. So but later on the parliamentarians amended the provision and forced the Prime Minister to resign when a motion of no confidence was passed. So the current Prime Minister was faced with such a scenario, and the Constitutional Court was approached, and the Constitutional Court said, look, this clause is unconstitutional. This amendment of the Constitution goes against the basic structure of the Constitution, in the sense that it robs the Basotho population the power to decide what to do when the Prime Minister is toppled before the Parliament. So then the Court of Appeal approved that to say, no, look, you 120 guys there cannot deprive the entire nation of the right to elect who to govern the affairs of the country. Thank you.
Thank you very much. We can see how practical this course is, and that we have actually been encountering it without knowing, without understanding what was at play. And sometimes we blame the judiciary for giving whatever judgment that did not go down well with us, and we do not appreciate the principles at play behind the scene. So that is what this class is doing for us. Let me see if we can quickly take one more before we are logged out, but be assured that tomorrow we will go through this again, particularly for the benefit of our Lesotho brothers and sisters who are not able to join us today. Okay, so do we have one more volunteer, or I should call name? Lekaka, I doubt if you have said anything in today's class. Lekaka, give us your understanding of one of the canons of interpretation. Okay, Teboho, your hand is up. Go ahead.
Thank you, Ebenezer. I'm looking at number 3. I think it's closely related to number 12, in that they relate to the golden rule. Both of them are more related to the golden rule. We will recall that the golden rule is used to avoid absurdity. So as we interpret the Constitution, we must ensure that we avoid absurdity. Absurdity will be an unconstitutional result. That's my understanding of 3.
Thank you. I have been warned. We end in less than a minute. So please, tomorrow, let us endeavor to join the class early. And for those who are not here, remind them, tell them how interesting today's class was and how relatable it was. Tomorrow, we shall continue, or we shall revisit this entire topic. Thank you very much. Do have a wonderful day. Goodbye, everyone.
Thank you very much, Prof. I really appreciate you, sir.